Good morning and good afternoon, everyone, depending on where you are. Welcome to the Navigating the Duty to Accommodate in Canadian Workplaces webinar. This is the third webinar in this year's Fasken five-part fall labor series. My name is Boris Subara, and I'm a partner in Fasken's Ottawa office. I practice in all areas of labor and employment, providing advice and representation to both unionized and non-unionized employers and management on any and all issues that could arise during the employment relationship. Before I introduce my co-presenter today, please see the administrative information that is outlined on the screen before you. I'd like to draw your attention to the survey and the CPD certificate points. So QR codes and links will be available at the end of the event to fill in our survey, as well as to obtain your Ontario, Quebec, or BC CPD certificate and credits. So we would really appreciate it if you could take some time at the end to fill out our survey. Joining me today will be Kyla Tabibzadeh, who's an associate in the Labor, Employment, and Human Rights Group in our Toronto office. And Kyla, like me, also maintains a broad practice, also assists unionized and non-unionized employers on a variety of issues: wrongful dismissals, contract drafting, grievance arbitrations, and of course, workplace accommodations, which is the topic of your presentation today. Regarding questions, thank you for those who have submitted yours in advance of today's date. We've received over 60 questions in advance, so thank you for those. We'll be aiming to leave a few minutes at the end to answer as many of those as we can. And if any questions pop up, you have any during the presentation, feel free to write them in the chat box, and we'll try to answer those as well, either live or in writing. So on to the next slide. Here's our roadmap for today. And I'll begin by saying that the presentation today is not meant to provide a general overview of the duty to accommodate or a basic workplace accommodation 101 session. We will spend a bit of time at the outset talking about those general concepts, but our focus really will be on recent case law developments that illustrate how those principles are applied in practice and in the real world. And all of the other webinars in Fasken's fall series had sort of a 2025 year in review theme, and this one will be no different. So we did pick a few cases from this year, from the last year, which highlight the nuances of accommodation obligations in Ontario and in Canada. And those will help you understand how tribunals and labor arbitrators interpret concepts like undue hardship, the procedural versus the substantive duty to accommodate, and the various legal tests for discrimination. And so by reviewing these cases, we're aiming to give you some practical insights that go beyond just the theory, as well as to show you how the law is evolving. And our cases this time around are mostly Ontario cases. I believe all of them are from either the Human Rights Tribunal of Ontario or labor arbitrators, but the duty to accommodate is generally consistent across all of Canada. So for those of you who may be from another province, do not worry. This presentation will still be very useful to you. So before we jump into the cases, I wanted to briefly introduce some very general concepts, starting with an overview of the accommodation law in Ontario and federally. So as we know in Canada, employees have a fundamental right to be free from discrimination in employment. And that principle is embedded in both federal and provincial human rights legislation. If you're federally regulated, banks, airlines, telecommunications companies, You are governed by the Canadian Human Rights Act. Most other employees fall either under provincial or territorial human rights codes. And every single province and territory has their own legislation, but they're quite similar. And every human rights code in the country will touch on the common grounds of, for example, race, sex, age, disability, religion, family status, and so on. There may be some unique protected grounds in some provinces, like, for example, political belief, which is a protected ground in BC, and I believe in a couple other provinces. But overall, the core principles are really similar across Canada, with some small nuances. And all of these laws will prohibit discrimination in all aspects of employment, but that also includes hiring, and it includes promotions, training, and termination. And we had someone ask us the question before this webinar: does the duty to accommodate apply during probation or early employment stages? And the answer is yes. It even applies before employment, for example, during the interview process. And as we'll discuss in more detail later on, if an employee is adversely affected because of a given protected characteristic, the employer will then have a legal obligation to accommodate that employee to the point of undue hardship. And we'll see what that means. Today, our cases will focus mostly on three grounds that frequently give rise to accommodation issues, or most commonly. And those would be creed in Ontario, which really means religion, but can also include other belief systems; disability, which covers both physical and mental conditions, as well as could be substance dependence, alcohol and drug addiction as well; and family status, which relates to caregiving obligations, most often child care obligations, but could also be elder care obligations. And we choose to focus on these because those are the ones that most often require employers to make adjustments to their workplace policies or practices in the workplace to ensure equal treatment. So what is the duty to accommodate? If we move on to the next slide, the duty to accommodate is not a single obligation. And many of the cases we're going to look at today talk about that. There are two distinct components, both a procedural and a substantive component, and both must be satisfied for an employer to meet its legal responsibilities. So the procedural duty refers to the process that the employer follows when responding to an accommodation request, and that process must be meaningful. It's not just checking the boxes. The employer must actively engage in a dialogue with the employee, gather relevant information, and explore possible solutions. Assessing, different options. A failure to investigate or to consider alternatives and what steps, if any, can be taken will amount to a breach of the procedural duty. And that's true even if the final decision seems reasonable, right? So kind of like terminations for just cause, even though you may be right, even though you may have had just cause to terminate an employee, if you didn't follow the procedure to get there, if you didn't investigate, give the employee an opportunity to respond, and so on and so forth, you can still lose that case, right? And so accommodation is no different. The substantive duty, on the other hand, will focus on the outcome, and the accommodation provided must be appropriate or reasonable, not necessarily perfect, as we'll discuss. But very simply, if an employee requests modified hours for a religious holiday, offering them unpaid leave instead of adjusting the schedule may not satisfy the substantive duty if a less disruptive option is available. And if no accommodation can be provided, the employer has to be able to demonstrate why that is. And again, that's not easy. So courts and tribunals consistently have emphasized that both components are essential. We can't satisfy the substantive duty if you haven't also satisfied the procedural duty. And as we'll discuss in a minute, the duty to accommodate is a shared responsibility, which colloquially is often referred to as a two-way street, which means the employee also has a duty to collaborate. But at the end of the day, it's the employer who bears the burden of demonstrating that it met both the procedural and substantive requirements. So moving on to the legal tests in accommodation, it's a two-step process, right? Uh, the first step really is prima facie discrimination. So if an employee can establish, and this test is very straightforward, the employee also only has to establish that one, they have a protected characteristic, two, that they experienced an adverse impact, and three, that there is a link, or as we often say, a nexus between that protected characteristic and the adverse impact. So again, if an employee is disciplined for missing work due to a religious holiday, and the absence was directly related to their religion, that would establish prima facie discrimination. And sometimes even a neutral rule can, or a neutral policy can adversely affect an employee. So a neutral attendance policy that says you're fired if you have this many absences, or you're disciplined if you have, I don't know, how you miss this many days of work. That can adversely impact an employee who needs time off for medical treatment, right? Because their absence in that case is not a culpable absence. It's innocent because of their disability. And if that first step is met, the employer must justify its actions and demonstrate accommodation efforts. And that is the second step. So the burden then shifts to the employer, and the employer must demonstrate that it has considered all reasonable options to eliminate or reduce that discriminatory impact. And that can take many forms, as we know: adjusting schedules, modifying duties, providing assistive devices, granting leaves of absence, and so on. And the key really is flexibility and creativity. Employers should document all of their efforts and maintain open communication lines with employees during the process. It's an individualized analysis, so not every solution will work for every employee. And there is also, this two-step process ensures that there's always a sort of balancing act between the interests of the employee and those of the employer, who at the end of the day has a business to run. One thing I'll note, and we'll see it in some of the cases, is if the employee can demonstrate that their protected characteristic was a factor in the employer's decision, that will be enough to establish a failure to accommodate. So a lot of the time, employers don't really grasp that, and they may think, we're firing this person because they're not performing, and that may very well be 95% of the reason why. But if there's even a 1% or 5% of that decision that is based on a protected ground, that can amount to a finding of discrimination. Now, quickly moving on to the next slide, just a quick word on bona fide occupational requirements, which we also call BFORs. What is that? In simple terms, it's a rule or a requirement for a job that is that allows us to legally discriminate against an employee because it's essential to performing the job safely or effectively. And the common example I always give is that of a firefighter, right? A firefighter must be physically able to carry heavy equipment or people, right? So that requirement might exclude some people. It might exclude some people with physical disabilities, right? But it's considered a BFOR because it's necessary for the core duties of the role or for the safety of others. And there's a million examples, right? Airline pilots, your vision, has to be 2020. You can't hire a person who's blind to pilot a plane, and that kind of thing. Moving on to undue hardship, and we'll get into a discussion about undue hardship through all of the cases we're going to review today. But what is it really? In a way, it's sort of the upper limit of what the employer will be expected to do in order to fulfill its duty to accommodate. So the employer is not required to go past that point, but to get there is not easy, right? And it's always determined on a case-by-case basis. But at some point, due to financial reasons or safety reasons or health and safety reasons, and other practical constraints, there may be a point in time where going further for the employer would be undue, meaning unreasonable, impossible. And at that point, the employer is considered to have discharged their duty to accommodate. But undue hardship, and we have a lot of clients with questions about undue hardship, but a minor inconvenience or a disruption is not going to be enough, right? So just because it's frustrating or just because it's difficult for you to adjust someone's schedule, make changes to a policy, temporarily reassign tasks and that sort of thing, or tolerate some level of absenteeism, that is not going to get you to the level of undue hardship. Likewise, low to moderate financial costs also will not get you to undue hardship. But really, when we're talking about finances, we're talking about an amount of money that is almost threatening the viability of the business, of the company. So just because we have to spend a couple $1,000s for an assistive device, for example, that is not going to discharge our duty to accommodate. Likewise, something we often see, the floodgates argument is not a defense. So sometimes employers will say, can't do this because if I allow that person to do that, then I have to let everybody else do it as well. So it's not a real argument or a defense unless and until it really happens. So you can't say, I won't do it because I know this is going to flood the gates. But if it does eventually flood the gates, then at some point you may have an argument to say this is financially prohibitive, or there's another constraint there that means this is no longer doable for the business. So moving on to the next slide, I will turn it over to Kyla to talk about religion and creed, as well as our first case.
Perfect. Thank you, Boris. So religious accommodation, or accommodation based on creed, is actually one of the most common and complex areas of workplace accommodation. Under the Ontario Human Rights Code, creed is defined quite broadly. It includes not only traditional religious beliefs, but also non-religious belief systems that are sincerely held and integrally connected to a person's identity or way of life. This means that accommodation is not limited to those mainstream faiths. It can extend to smaller or less familiar belief systems, provided they meet this broad legal definition. Employers have a duty to accommodate employees' religious practices unless doing so would cause, as we said earlier, undue hardship. Common examples of this include adjusting work schedules to allow for prayer times, granting time off for religious holidays, or modifying dress codes to permit religious attire, such as hijabs, turbans, or kirbans. Dietary restrictions during workplace events could also fall under this duty. It's important to note that the duty to accommodate is not unlimited. Employees must make their needs known and cooperate throughout the process. Employers, in turn, must explore reasonable options and cannot dismiss requests without proper consideration. Recent case law actually emphasizes that sincerity of belief is key here, not whether the practice is mandatory according to any religious doctrine. And we've actually seen this in many vaccination cases as part of the COVID-19 pandemic. If an employee sincerely believes that a practice is part of their creed, it may trigger this duty. Unless there is a significant reason to believe otherwise, employers should generally accept in good faith that a person practices a creed where they say they do. So, moving on to the first case, Lauder and Huron-Perth Healthcare. This is a Ontario tribunal case, and in this case, Lauder was a housekeeper at the hospital, and she refused to comply with the hospital's mandatory vaccination policy, and she cited her religious beliefs. The applicant worked unvaccinated for years due to an administrative oversight, but Huron later discovered that she had no immunity to measles, mumps, or rubella, and she refused to get the vaccination. The hospital maintained a mandatory vaccination policy for all staff, grounded in health, safety, and provincial protocols. As a result, she was placed on first a paid leave and then subsequently an unpaid leave because she declined to get the MMR vaccine. She argued that her Christian beliefs prohibited vaccination and that the hospital failed to accommodate her creed. As part of her faith, she believed that God created all things by intelligent design and created her in his perfect image. She asserted that vaccinations are unnecessary because her immune system is perfectly designed and would defile her body, which was a temple, and alter the God-given DNA. In this case, the tribunal accepted the applicant's beliefs were sincerely held, but found that they were more personal interpretations and not really part of an overarching religious system. While an individual does not have to establish that every member of their religion has the same view on vaccines in order to establish a connection to a creed, there must be at least a settled understanding within the religion of the existence of such an interdiction. The applicant's objections were largely health-based and autonomy-based, and not really creed-based under the code. Despite this finding, the tribunal, for the sake of completeness, proceeded to assess the duty to accommodate and found that the employer had satisfied its duty. The employer promptly requested documentation after Lauder raised her beliefs and conducted an in-depth review of possible accommodation. The employer also maintained Lauder on a leave during the accommodation process. As part of the accommodation process, the hospital conducted a month-long review where they consulted public health authorities, conducted a skills assessment, and reviewed every posted position for suitability. Ultimately, the hospital concluded that no available role could safely accommodate Lauder's unvaccinated status. As a result, the hospital demonstrated undue hardship. They could not isolate Lauder from patient areas given the nature of her duties, and there were no available roles that did not involve patient contact. The tribunal emphasized that accommodation must be reasonable, but not ideal, and that safety-sensitive environments, like a hospital or a clinic, may impose those stricter limits on accommodation in the name of safety. So what are some lessons we can take away from this? First, document the accommodation process. We as lawyers always say CYA. The tribunal relied heavily on the employer's detailed records, emails, meeting notes, and the rationale for the decisions. Second, explore all reasonable alternatives. Even if options like remote work or reassignment seem impractical, you need to demonstrate that you actually fairly considered them. Third, consult experts and follow guidelines. In Lauder, the employee engaged infection control specialists and relied on public health directives. Fourth, there are limits to accommodation. Employers are not required to create new rules or lower qualifications. Unfortunately, in this case, there was no role that would not be patient-facing available to the applicant. Also, the employer is not required to compromise on health and safety. The vaccination requirement was upheld as a bona fide occupational requirement because it was essential for patient safety. Finally, a singularly held belief with no connection to a shared religious belief system may not be considered a creed under the Human Rights Code. I'm going to pass it back over to Boris to talk a little bit about disability accommodation.
Thank you, Kyla. So moving on to disability, which I would suggest, I know we just said religion is complex, but disabilities is probably, well, first of all, the most common protected ground we would find. But I would suggest the most difficult to grapple with, even for us lawyers, because it's just so incredibly fact specific. As opposed to creed, the Ontario Human Rights Code does include a definition of this of disability, which you see here on the screen. But generally, what is a disability? It's anything that, any degree of physical or mental disability that is visible or non-visible, that may or may not be permanent, um, could be considered a disability. It includes the fact that a person used to have a disability, could also include the perception of having a disability. Uh, and those physical and mental disabilities can vary greatly in severity, and how they impact the employee's ability to work, right? And as I said, they can be permanent, they can be temporary, they can be progressive in nature. Um, Human rights tribunals, however, have consistently held that commonplace temporary illnesses that are short term or non chronic and do not significantly impair the employee's ability to perform work are not disabilities requiring accommodation. So, someone with a cold or a flu is not considered to be disabled. Or someone who's recovering from a surgery may not necessarily be considered to be disabled. But you always have to keep an eye on things because complications from a surgery can eventually lead to a more serious disability. And I'll just say a quick word on addiction because people forget sometimes that addiction has been considered a disability under human rights case law. So substance dependence, alcohol and drugs, which in turn means that disciplinary action, including termination for any type of misconduct related to an addiction, must be carefully considered. And typically, employers will, at least at the outset, be required to focus on rehabilitating the employee, exploring accommodation options before imposing automatic termination. But that may not always be possible, right? And the employee may be in a safety sensitive position that, simply put, cannot be accommodated. Are there other things that the employee can do? Maybe, right? So again, it's very contextual, and it's highly fact specific. But on to the next slide, I'll talk about the first case of disability, an interesting one, the case of Mr. Burgraff, who was blind, completely 100% blind. And he applied for a sales associate position at Convergys in 2017. And there was no dispute at all during this hearing that his blindness was the reason he was not hired. So everybody knew he was blind. Everybody knew that was the reason they didn't hire him. They otherwise liked him as a candidate, but his blindness could not be accommodated, said the employer. And the central issue here was whether the employer, fulfilled its duty to accommodate to the point of undue hardship. So Mr. Burgraff disclosed his disability during the hiring process, right at the interview, right? And he requested accommodations. And one particular thing he requested was a screen reader with Braille display. And the employer acknowledged these needs and indicated to him that they would explore what solutions might be available. And then, the evidence shows there was a bunch of emails confirming, first of all, the employer's awareness of his disability, and the employer actually taking active steps to explore different types of software and assistive technologies. For example, JAWS software, which I learned is a screen reader that provides Braille output for computer users who are blind or visually impaired. So just grabs information from the screen and it converts it to Braille. Um, Here, however, the employer's only client was AT&T. And any work that any employee of the company would typically do would involve necessarily working with AT&T's software. And so what the employer did is they conducted some internal testing and they concluded that none of the screen reader programs that they had at their disposal or that they could think of worked with AT&T's proprietary software. Like that there was no way that the reader could grab information from the screen using AT&T's software. And so for that reason, they simply called the candidate and said they could not proceed with his job application. On to the next slide. After reviewing the evidence, the tribunal found that the employer failed in both its procedural and substantive duties. On the procedural front, what happened is, first of all, the employer never consulted the applicant after the original interview. And what's really interesting in this case is Mr. Burgraff was basically the god of accessibility technology. This person knew everything about this field. He had, done work previously. He had been consulted previously, in other aspects of his life. And he was truly, truly an expert in this sort of stuff. And they never called him after the interview to ask any questions. They never tried to get more information from him, to test different things, to explore alternatives, to see if there could have been some sort of workaround. And the employer also did not consult or engage its client, AT&T, or any other external organization for possible solutions. Although they did, internally look at a few things. So that was a procedural failure, right? The employer did not explore all options available. And then on the substantive front, the employer did not provide any evidence of the cost analysis or any efforts to adapt its existing systems. It did not demonstrate that working on a compatibility solution, when it came to AT&T software would cause undue hardship. And in fact, the evidence at the hearing showed that getting the required technology would only have cost somewhere in the realm of $2,000 plus a small annual fee. So really not that expensive and definitely not cost prohibitive for a company of this size. The tribunal emphasized that speculative concerns, right? So your belief that, this may not work is not enough, and neither is after the fact justifications. So they really failed at the procedural stage, and they could not justify the substantive prong either. There was an expert witness here at the hearing, which was held in 2023, and that expert witness, admitted that it might have been difficult in 2017 when these events took place to make this work because the technology was not as advanced as it is today, but that ultimately it would have been possible, right? And as a result of that, the tribunal rejected the suggestion that navigation of AT&T's proprietary software was a bona fide occupational requirement. The tribunal found that with the proper tools, the applicant could likely have been able to perform the job. And what's also interesting is this applicant did find a job sometime later, also working in the tech industry and performing his duties just fine still, to this day or to the day of the hearing. So failure to accommodate on the part of the employer, the tribunal awarded $20,000 for injury to dignity, feelings, and self-respect, as well as lost wages for the period of time that the applicant likely would have worked for the employer. And the tribunal was satisfied that had it not been for the candidate's blindness, he would have been the successful candidate, right? Because they really liked him as a candidate, and he had all of the qualifications. So next slide. What are some of the lessons from this particular case? Well, number one is that employers must provide accommodation even in the hiring process, right? Before the candidate even becomes an employee. It must pursue accommodation in collaboration with the candidate or the employee, which the employer failed to do here. As we said, they failed to consult him, to ask him, is there anything else that we're missing here? Is there anything else that we can do to make this work? They didn't do that. And accommodations cannot be dismissed based on the assumption that something is going to be too difficult or that it cannot be done, or after the fact realizations that this would not have been possible even had we tried, right? So you actually have to try it before you come to that conclusion. Moving on to the next case, Wissahick and Sunnybrook Research Institute. Here we have an employee who claimed that after experiencing sexual harassment at work, she developed a disability and was subsequently denied accommodation and was subjected to reprisal by the employer. And she was alleging all sorts of delays regarding her return to work. She alleged that the employer demoted her because she tried to assert her rights and harassed her during the accommodation process. But if we go back to the beginning of the story, the applicant began a sick leave in December of 2016. So this, quite some time ago. This case was only decided in 2025, but the events started in December of 2016. She had provided a medical note from her doctor saying that she's unable to return to her previous role at Sunnybrook. And the employer provided her with a very generous paid leave of absence of 14 months. And the employer, starting sometime in late 2017, tried to get her to get back to work. And they offered her a number of alternate positions, which the applicant consistently turned down. And suddenly the applicant started insisting on returning to her previous role, which was, higher paying role. But that was, of course, contrary to the doctor's advice, who had previously said or had previously recommended against returning to her previous role. So the employer requested an independent medical evaluation, IME, because there were concerns about inconsistent medical information. And that IME confirmed that the employee could return to work, but not to her previous position. I would also note that the employee failed to cooperate during the IME process, and we can switch to the next slide. So she refused to participate in the IME, first of all. Later, she agreed to participate, but refused to provide her consent for her doctor to send copies of her medical file to the IME doctor. And she was basically the source of the delays here. And even after the IME confirmed her ability to come back to work, she caused even more delays, ultimately reluctantly agreed to go back to an alternate role, which was not her previous role. And given all of the efforts that the employer made over the course of, was really 3 years almost, the tribunal found that the employer met both its procedural and substantive duty to accommodate. So on the procedural front, when we look at what the employer did, the employer stayed in contact with her for the whole time. The employer sought medical information. The employer paid 14 months of leave. The employer arranged for an IME, which it also paid. The employer considered on the substantive front 2 alternate positions, and they ultimately reinstated her to another suitable role. It even agreed to compensate her at the top of the pay scale for that position to mitigate the reduction in income she was now suffering compared to her previous role. So the employer did everything right, and it was the employee who failed to cooperate in this case by refusing these alternate positions, causing delays, refusing the IME, delaying medical documentation. And the tribunal emphasized, and this is a common question we received from many of you, that reasonable accommodation is enough, even if it does not match the applicant's preference. And the duty to accommodate does not guarantee a perfect accommodation, not even the employee's preferred accommodation, and not even the doctor's preferred accommodation. So you're always allowed to explore other options and pick whatever works best for the employer as long as it's still reasonable. So her allegations of harassment and reprisal were also dismissed due to lack of evidence. This is an interesting case as well because the employee, and it sort of, I guess, shows the employee's character. The employee was not allowed to testify at this hearing because no witness statement was filed by her, as had previously been directed by the tribunal. So the only witness here on her behalf was her doctor, who admitted she knew very little about the employer's workplace, was not really in a position to comment on whether these other roles were suitable or not, and that all of her knowledge was really based on what her patient had relayed to her. So certainly that did not help the employee's case, right? Next slide. What are the lessons from the Wisik decision? Well, as I just said, but it's worth repeating. Employers are not required to provide perfect or preferred accommodation as long as it's reasonable. And sometimes, in my practice, I see employees provide medical notes with, a request or a recommendation from the doctor. But we are allowed to go back to the doctor and ask, is there something else that would work here? What if we did this? Would that work? Would that accommodate the disability, for example? And oftentimes the doctor is forced to admit, right, that whatever we're proposing now is reasonable and is compatible with the employee's restrictions and limitations. And the second big lesson from this case is that the employee's failure to cooperate will undermine a claim that the employer failed to accommodate them, because again, accommodation is a two-way street, and the employer cannot satisfy its duty to accommodate unless the employee is cooperating, and that means remaining open to reasonable accommodation, but also the more simple things like providing medical documentation when requested, going to the IME when requested, and so on and so forth. And I'm kicking it back to Kyla.
Thank you, Boris. So the next case that I'm going to be talking about is IPEX and the United Steelworkers case. It's actually, I think, our only labor arbitration case that we have today. But here we had the employee, Ron Robertson. He was a setup process operator at IPEX's plastic injection molding plant, and he was terminated for breaching a last chance agreement after failing to follow the call-in procedure on 2 occasions, May of 2023 and June of 2023. The union here argued that Robertson's alcohol dependency constituted a disability under the Human Rights Code, and therefore his termination was discriminatory. So Robertson had a history of attendance issues and often failed to follow call-in procedures, and this dated back long before 2023. It was about 2017. And since then, he had received multiple warnings, suspensions, and even counseling. In November of 2022, Robertson was actually terminated for absenteeism, but was then reinstated in February of 2023 under a last chance agreement that was negotiated with the union. And this agreement was supposed to be effective for 2 years until February of 2025. The last chance agreement was pretty explicit. It said that any further failure to follow attendance protocols would result in immediate termination. It also acknowledged that Robertson's participation in counseling and support programs and included a referral to the Employee and Family Assistance Program. So, like I said earlier, in May and June of 2023, Robertson again failed to follow the call-in procedure, and he did not notify the employer of his absence before the start of his shift, and he cited reasons such as sleeping and traffic delays. So, at arbitration, the arbitrator found insufficient evidence of an active alcohol dependency in June of 2023. The griever also did not attend the hearing or provide updated medical documentation. A urine sample that was taken during his employment showed that there was no alcohol use, and counseling reports indicated successful completion of treatment. So, the arbitrator found that there was no link between the griever's fail to call in and any disability. His absences were attributed to, like I said earlier, reasons like sleeping in, a sore throat, traffic delays, and none of these were connected to alcohol use. Despite these findings, the arbitrator conducted an analysis of the accommodation offered by the employer for completeness. The arbitrator found that the employer accommodated Robertson to the point of undue hardship when they referred the griever to counseling services, provided multiple warnings and suspensions, reinstated him under a detailed last chance agreement, and provided multiple opportunities to correct his behavior. The arbitrator concluded that the employer had essentially exhausted all reasonable accommodation efforts, and continued tolerance would constitute undue hardship, especially given the safety-sensitive nature of the role. So what can we take away from this? First, employers are not required to accommodate speculative or historical disabilities. The duty to accommodate is triggered by present needs and not a past diagnosis. While he did suffer from alcohol-related disability, it was no longer the case in June of 2023. Also, in a case of alcohol or substance use disorders, successful completion of treatment and absence of relapse may negate the need for any additional accommodation. And employers can rely on last chance agreements as part of a structured accommodation plan. So it's nice to see that this was actually enforced, and employers should ensure that such agreements are negotiated in good faith and include support measures like counseling. So next, I'm going to actually move on to our third type of accommodation we're talking about today, and that's family status accommodation. So family status accommodation deals with obligations arising from family relationships. Most commonly, this is child care or elder care responsibilities. A typical example is an employee who can't work certain shifts because they need to care for a child or an aging parent. Employers must consider whether adjustments can be made. This could include flexible scheduling, maybe even remote work arrangements. The legal test for family status has evolved. The test generally requires employees to show that the obligation is substantial and that they've made reasonable efforts to self-accommodate. So, for example, there may be other supports available to the employee. If a parent asks to leave work early instead of finding after-school care for their child, that may not warrant an accommodation from the employer. The courts have moved towards kind of a contextual approach, focusing on whether the workplace rule creates a serious interference with family obligations. The negative impact must result in real disadvantage to the parent-child relationship and responsibilities that flow from that relationship and/or to the employee's work. It's also important to note that family status accommodation does not guarantee, as with all accommodation, does not guarantee an employee's preferred schedule. The duty is to explore reasonable options, not to provide the perfect solution. Employees also share in that responsibility. We talked about the two-way street, but employees must communicate their needs clearly and cooperate in finding workplace arrangements. Recent cases actually highlight the growing importance of family status accommodation, especially as workplaces adapt to changing demographics and caregiving demands. For instance, if the employee is a single parent, both the family-related need and the impact of the impugned rule on the family-related need may be greater. Employers should approach these requests with flexibility and avoid rigid one-size-fits-all policies. So the first case we're going to be talking about here is a Ontario Tribunal case, Curselli and Pet Science. Curselli was a delivery driver for Pet Science, and he claimed his employment was terminated because the company failed to accommodate his caregiving duties for his elderly mother. She needed to be accompanied for her medical appointments. And in September of 2019, he asked the employer for 11 vacation days during high season, a very busy period for the employer. The request was approved, but as an unpaid leave. And when Curselli realized this, he withdrew his request. He was subsequently terminated, and these were due to performance issues, including missed deliveries and customer complaints, which were actually well documented. That being said, Curselli argued that the dismissal was linked to his caregiving needs and therefore discriminatory. The tribunal found that while Curselli's mother had legitimate care needs, he did not clearly communicate these to the employer before his termination. The only reference to her illness came after his termination via a text message to the employer. Earlier vacation requests were actually just framed as personal and not related to family status or caregiving obligations. So there was no evidence the employer had been advised that the employee's mother required accompaniment to medical appointments or had an illness requiring care. The evidence showed that the employer actually approved time off for the appointments and did grant these 11 vacation days during the busy season, and the employer was not required to pay for that time off as accommodation. Additionally, the tribunal accepted evidence of performance issues. There was documented infractions signed by the employee and various customer complaints. These issues predated any accommodation and were unrelated to caregiving, and these formed the basis for termination, not family status. Ultimately, the tribunal concluded that the applicant failed to establish his termination was discriminatory. What are some lessons we can take from Curselli? First, employees must explain caregiving needs and cooperate in finding those solutions. Both the employer and the employee must actively participate in the accommodation process. If they expect accommodation, employees need to state their needs and responsibilities. There is no duty on the employer to inquire when they're not given any information. They're not expected to guess or investigate undisclosed personal circumstances. Also, back to CYA, performance management is crucial. Documented performance issues unrelated to family status or whichever ground is being claimed in your circumstances can justify termination. So make sure to keep clear records of infractions and complaints. Finally, offering unpaid time or vacation days can satisfy an accommodation obligation. Employers aren't necessarily required to pay for time off unless contractually obligated. I'm going to pass it back over to Boris to finish the last couple cases.
Thank you, Kyla. So I'm moving over to Kane. We're still under family status, and this one had to do with childcare obligations. The employee here, Lucy Kane, was the director of merchandising at JTEX, and the employee went on a parental leave in December of 2018 and was scheduled to return to work a year later in December of 2019. Regarding her childcare needs, the employee, upon sometime before her scheduled return to work, requested a modified start time of 9 a.m. instead of 8:30 to accommodate her daycare drop-off. And she offered to make up the time by working through her lunch hour or working from home or on the weekends, and that sort of thing. And the employer initially agreed to this and even suggested delaying her return to January of 2020 to ease her childcare transition. But on December 16th, 2019, just a few days before her scheduled return to work, the employer terminated her employment, citing financial difficulties and restructuring. Other employees were also terminated a couple of months later as part of a group termination. Moving on to the next slide, the tribunal found on the issue of accommodation that the employer did meet its procedural duty by agreeing to a modified start time. They offered her different work from home options. They even offered to delay her return to January. So there was no breach of the duty to accommodate regarding the schedule change, which was fairly minor. It was only a 30-minute delay compared to her usual start time. But on the termination front, the tribunal concluded that the employee's family status was a factor in the decision to terminate her employment. So there was evidence here, including internal emails, internal correspondence, where the employee was singled out as someone that the company absolutely cannot bring back. And this was, explicitly said in an email. She was also often identified as the mat leave employee in correspondence, internally and externally. There was also evidence, interestingly, from former and current employees of the company that showed that the workplace culture there was unsupportive of women with childcare obligations. And there was even evidence here that her supervisor had asked her to hire a nanny and, in fact, discouraged her from putting her child in daycare because that would increase the chances of her child getting sick and therefore her having to miss work. The company did argue that the termination was due to business restructuring. And that was actually true because the company did close several stores and several employees had been let go as a result. But the problem is this happened a couple of months later. And the tribunal noted that the decision to terminate this employee in December, 2 months before all the other terminations, was premature and paternalistic. The employer argued that they were doing her a favor, really. They didn't want to be cruel to her by bringing her back only to terminate her a couple of months later. But in reality, this deprived her of the right to return to work after her parental leave. And the evidence also showed that there were no other employees who were terminated in December of 2019. She was the only one. And, the tribunal noted that if she had been terminated at the same time as the other employees 2 months later, there would have been no breach or failure to accommodate. So that's interesting. But the fact it terminated her early indicated that there truly was an element here related to her family status. And this goes to what I was saying earlier on in the presentation, that if the decision is even in part based on a protected ground, that amounts to discrimination, even though here, the overwhelming reason here for the termination was the fact the company had been closing dozens and dozens of stores at the time. So the tribunal awarded damages, lost wages, and interestingly also a non-refundable daycare deposit that the employee had to pay to the daycare center, which she did not end up using as a result of her losing her employment. Moving on to the next slide. Lessons. I think the most important lesson here is be careful what you say, be careful what you put down in writing, because all of that can come out in the evidence. And here there was, ample evidence of conversations with the employee where they told her, don't send your child to daycare. You're going to get sick. You're going to miss work. There were emails where they referred to her as someone they absolutely cannot bring back. They called her the mat leave employee. All of these things are, communications that you may not expect will ever come out in the public sphere, but they very well may. And if an employee brings a complaint, either an application to the Human Rights Tribunal or a civil claim, that will all come out in the evidence because it's all relevant to one of the issues in the matter. And here, simply put, the internal communications very clearly showed that this employer promoted a culture prioritizing work over childcare obligations. And moving on to the last case for today, Cosentino and Octa Pharma. Here, the employee Lydia Cosentino worked as a national health sales representative for Octa Pharma Canada. And in 2020, her mother was diagnosed with cancer. She became the primary caregiver during the COVID-19 pandemic. And we received a lot of questions from you regarding return to office mandates. And this is one of these cases that touches on that a little bit. The key issue here was whether the employer failed to accommodate her family status and whether her termination amounted to a reprisal for asserting her code rights. So the employee's role here was primarily field-based. And since March of 2020, because of the pandemic, most staff were working from home due to pandemic restrictions. And when I say her role was primarily field-based, that means this is not someone who was required to report to the office, or if she did, it was only sometimes. But her primary work location never was the head office. In August of 2020, so right after the pandemic started, her mother had began chemotherapy sessions and radiation. And hospital protocols at the time allowed only one consistent companion. So that employee, in this case, Ms. Cosentino, assumed full caregiving responsibilities for her mother. And that requested a lot of flexibility because there were a number of medical appointments the mother had to attend. And the employer initially granted all of those. The employee was allowed to leave. You know, she was working from home, but she was able to leave and take calls from the car and take calls from the hospital. And all of that was working relatively well. But the problem is the mother was quite ill and needed more than just assistance with her medical appointments. In fact, the mother had also broken her wrist and needed help with cooking and eating and cleaning and laundry and basically all these other daily tasks. And for that reason, the employee had to be home. In September, the employer issued a performance improvement plan to Ms. Cosentino, citing sales concerns. The reality is, it was the pandemic. The company was not doing well. The company was not selling well, and some employees were placed on a PIP for that reason. And finally, in October of 2020, the employer announced a change requiring her to work from the head office starting on October 26th. And this was despite the fact, as I said, that this employee did not work from the head office before. And despite the fact the pandemic was still very much a concern in October of 2020, as you will recall. So the employee requested accommodation to continue working from home, citing her elder care obligations and the risks associated to COVID-19. But the employer refused that request for accommodation and insisted on office attendance. And the evidence also shows the communication between her and her manager at that time effectively ceased. It's almost as if they stopped communicating with her. They started ignoring her. And finally, a couple of months later, about 6 weeks later in December, they proceed to terminate her employment on a without cause basis, with the employer suggesting that her performance was below expectations. So on to the next slide. On the accommodation issue, the employer did, at the very beginning, provide flexibility, but they failed to engage in any further discussions when the employee asked to continue working remotely. The employer never offered any other alternative, like partial office attendance or any kind of hybrid arrangements. All they did is they said, well, you come into the office, and if you need to drive your mother to the hospital, you can leave the office. and we'll allow you, we'll allow you time to do that. But that was not, that was not enough because the mother here also required care at home. And it was almost, it would have been impossible for the employee to go to the office, then drive back home. She was located in Woodbridge, the place of work was in Toronto. So it was just unthinkable for her, to ask her to drive home every time she needed to cook a meal for her mother or anything like that. The employer also argued that someone else should be taking care of the mother, like maybe some other family members or personal support workers. And the evidence demonstrated that the employee did, in fact, try and find help, but resources were scarce during the pandemic. And the employer also dismissed the employee's concerns about COVID-19, even telling her at one point on a call, stop with the COVID nonsense. But there was an expert witness here, an oncologist who testified at the hearing and confirmed that the mother was very much at a higher risk due to her cancer diagnosis. So ultimately, the tribunal found that the employer's conduct was a failure of both the procedural and the substantive duties under the code. And on the issue of reprisal, the tribunal also determined that um, when the employee asserted her accommodation rights, that's when the employer reduced communications with her. The employer started excluding her from calls and ultimately, a few weeks later, terminated her employment. And the tribunal concluded that these actions were, in fact, retaliatory and linked to her accommodation request. So, again, the tribunal awarded significant compensation, actually, in this case, $25,000 in general damages for injury to dignity, feelings, and self-respect, but a pretty hefty sum for lost wages. And it wasn't only lost wages, but also an amount for lost benefits and allowances, lost wages in terms of an annual performance bonus. And what I found interesting, there was also this 3-year profit sharing bonus that was vesting over a period of 3 years. It was for just over $50,000. And that bonus was supposed to vest just a few days after the termination date. And the tribunal even suggested that the employer's decision to terminate her just before the vesting date might also have been a calculated move to avoid paying out the bonus. So on to the next slide. What did we learn from this case? Well, we learned that we need to be careful when an employee has caregiving duties that are medically supported. And in this case, it's not medical evidence of the employee, but it's medical evidence of the mother in this case. And there was plenty of medical evidence there showing that the mother had all these different medical needs for which she required support. Another lesson learned is that the accommodation does not need to be perfect. We said that, but it still needs to be reasonable. And here, requiring that the employee work from home, that the employee work from the office was not reasonable because her mother needed help with all of her daily tasks, at least until her broken wrist could heal. And that was not going to be a forever thing, but it would have been a few weeks for the broken wrist to heal. And another lesson is, or another point I make is, this employee never worked from the head office. There was no reason whatsoever for the employer to require her attendance, especially not during the pandemic. But here, the employer felt that sales were slipping during the pandemic. And the reason it provided for requiring in-office attendance was to enhance collaboration among the team. And we received many questions from you regarding this, collaboration, teamwork. Is that enough of a reason to recall people to the office? Well, it is, of course, especially where employees were working from the office before the pandemic. But of course, if the employee has a protected ground, a protected characteristic, a disability, or childcare, elder care obligations that cannot be accommodated, then you may be in a position where you have to allow the employee to work from home. Typically, there will be things that you're able to do to minimize that, and there will be things you can implement to allow the employee to come into the office. But this was one such case where there was nothing really that could be done other than asking another family member to take care of the mother. So that concludes the cases that we had. We do have several questions, and we have some of them that we compiled from what you sent us before today's presentation, and we're also still receiving a number of questions in our chat box. So we'll start with the first question, and Kyla, I'll ask you to answer this one. How should employers handle family status accommodation requests related to return to office mandates or remote work related to which relates to what we just discussed?
Yeah, perfect. Very topical. So kind of like what you said, if the employee was previously working from the office, employers can generally recall them. If, the employee has a preference for working from home or wants to avoid the commute and things like that, that's not really a valid reason for accommodation. Family status accommodation, like we've discussed earlier, applies when caregiving responsibilities for children or dependent family members create a serious interference with work duties, and employees then requesting accommodation to work from home must show that returning to the office creates a genuine barrier and they've made reasonable efforts to resolve the conflict, whether that be, exploring childcare options or seeing if another parent or a sibling can assist. Um, Again, this needs to be kind of assessed on a case by case basis. Employers have to gather kind of the details about the caregiving obligations and consider maybe alternatives like flexible hours, hybrid arrangements, maybe temporary remote work while somebody's caring for a sick parent. Remote work is not automatically granted, and employers may decline if it causes undue hardship, like supervision issues or a big team disruption. But this all has to be documented. And again, always we have to distinguish between the need and the preference. If, like I said earlier, convenience or affordability concerns generally do not trigger accommodation unless they create an unavoidable barrier. So definitely make sure to document all your discussions and your rationale when having these conversations with employees.
Yeah, and if I can add to that, portability, sometimes employees will believe that we have to accommodate that, or that because they would prefer not to pay for daycare, for example, that we need to accommodate that. Well, that's not true. Um, First of all, we're not required to cover childcare and personal caregiving costs. And say an employee asks to start later because they have to drop off their child at school. Well, the question then becomes, is there a daycare service, where the child can go before school or after school, right? And if there is, that's an option we're allowed to explore, right? Just because the employee would prefer to simply drop off their kid at school and pick them up when school ends doesn't mean that they're not required to possibly look into daycare or other alternatives, right? And if, what about the other parent? What about grandparents? These are all things that you have to consider, and you have to really sit down, have a dialogue with the employee, understand, maybe it's a single mother. Maybe there is no other parent. Maybe there are no grandparents. Maybe this person is alone, living in this city. But that may not be the case. And if it's not the case, then we're allowed to explore those other avenues. Um, Another one for you, Kyla. What are the rules around medical documentation When is it required, and what questions can employers ask doctors?
Okay. So, if it's the first time an employee requests time off, like, they need a week off because they're not feeling well, you don't immediately contact the doctor. But I will say if absences become frequent or more difficult to manage, then you can reach out to the doctor with the employee's consent. I will say if the employee does refuse to consent, that's kind of considered a failure to cooperate in the accommodation process. So you require their consent, but they should really be consenting here. Um, so that would be one instance. Also, medical documentation becomes necessary when an employee requests accommodation due to a medical condition or disability. And, you'd be reaching out not for the purpose of, getting the diagnosis, but you just to understand the limitations and the impact on job performance. Employers can request this information at the start of the accommodation process when limitations change and or when they find that the initial documentation that was provided actually was insufficient. And the type of questions that you would ask physicians, you can ask, what kind of tasks can the employee perform? Are these limitations temporary? Are they permanent? What's the expected duration? What are the recommended accommodations? Is it ergonomic equipment? Is it modified hours? Employers can also suggest alternatives, right? If driving is an issue, can the employee take public transit? Can they take an Uber? So just avoid asking for unrelated kind of personal health details. And my recommendation for best practices would be just to use kind of standard forms, always maintain confidentiality, and again, document all steps.
Thank you, Kyla. Now I'm going to read a few questions from the chat box. We've answered several already during the presentation in writing, and I believe you have access to those answers. But I'm just going to ask a few. Uh, if an employee accepted a package which included a gag clause, which I assume is an NDA, non-disclosure agreement, but then realized that he faced a lot of undiscussed discrimination, can he put in a human rights complaint against the employer? No, not if the employee signed a full and final release, which I assume they would have if they accepted a package which included an NDA. I like to include in my release a paragraph that says that the parties have, in fact, discussed any and all matters related to workplace harassment and discrimination so that the employee can't later turn around and say, well, I didn't know that the release also included all these things. Um, can the employer ask the employee to seek outside help with the family responsibility duties? I mean, the employer can ask because that's part of the whole dialogue and the whole collaboration that we talked about today. Um, but it doesn't mean that the employee will necessarily be able to find outside help, right? And like in the Cosentino case, well, the employer did say, is there another family member who can help with this, or is there a personal support worker? There were no other family members that could help, right? I mean, those family members also have jobs, typically, but personal support workers were not easy to find at the time, during the pandemic. But in theory, yes, that is something that can be explored. Um, One that we already answered. Does an employee's reported inability to pay for childcare or other necessary family supports justify a need for modified duties? I would say no. Again, it can be highly fact specific. But the employee's preference not to pay, I mean, it'd be difficult to say, is this an inability, a real inability, or an actual just preference? But if they choose not to pay for daycare, um, that is not a consideration. Um, Kyla, any questions you want to Maybe I'll kick this one off to you. It's another one from the chat box. Does accommodation in a different role have to be at the same pay?
Yeah, of course. So, no, accommodation in a different role does not automatically have to be at the same pay, but there are kind of important considerations there. The best practice is to maintain their original rate of pay where possible. Um, but, if there is this requirement to there's this undue hardship. And if there's no role that the employee can be accommodated into that is the same rate of pay, the employer will not be required to maintain that.
Yeah, so that's exactly it. And the duty really is to find something that is reasonable. It doesn't have to be perfect, doesn't have to be what the employee wants. That's just the lesson today. One more question about medical information. The question is, can the employer terminate the employment if long absence and no probability of return to work in foreseeable future, based not on medical information, but on the insurer's conclusion, who analyzed medical information? Or do you absolutely need the medical info itself? So what I'll say there, and we're sort of talking about a different, I mean, it is part of the duty to accommodate, but we're also talking about another concept, which is frustration of contract. So in Ontario, for example, if it's very clear based on the medical information that the employee is unable to return to work in the foreseeable future because they have some sort of permanent disability, their condition is not likely to improve, they're currently off work, they're on a long-term disability leave, they've been there for a few years, and we're checking in and things are not improving, at some point we may be in a position to say that the employment has been frustrated, which means the employee will not be coming back to work. In such cases, we do have an obligation to at least pay out their statutory minimum entitlements under the Employment Standards Act in terms of termination pay and severance pay. But to answer this specific question, you would need the medical information itself before you come to that conclusion. You cannot rely on the LTD carrier's conclusion because they're looking at things from a different angle, and their interests are also not. And when I say interests, I also mean their obligations. So their interests and obligations are not the same as those of the employer. And they're simply looking at, does this person meet the definition of totally disabled in the policy? And that definition can be anything. And sometimes there's a formula in there, and the definition changes after 2 years, right? Is the person totally disabled from performing their own occupation versus any occupation at the 2 year mark? And, the LTD carrier, whatever they say, that is always subject to appeal, right? There's an appeal process. And even after the appeal process, the LTD carrier can still be taken to court. And a court could determine that their assessment was wrong. So we have separate obligations as employers, and we're looking at a different sort of test, which is this person, likely to return to work in the foreseeable future? A lot of employers make the mistake of assuming that if they're not back within 24 months, that's it, we're good to go, we can terminate their employment. That may not necessarily be true, right? And employment can be frustrated within a few months, or it can take years. And maybe the employee was off for 5 years, and suddenly there's a new treatment, and they're attending, they're maybe taking another drug, or there's a new doctor or something, and they're making some kind of progress. Then we still have to continue to tolerate their absence. Of course, the leave is unpaid. They're on LTD leave, and we're simply tolerating their absence. But that is part of our duty to accommodate. So a couple of questions here. We have a couple more minutes. A couple of questions about criminal history during the interview process. Yes, it can be a protected ground. It depends on the province. In Ontario, we're talking about record of offenses. And what this means is if a person has a criminal, conviction for which they have received a pardon, we may not discriminate or, refuse to employ that person on that basis alone. But in some other provinces, the test is actually quite a bit higher. And I know in BC, I know in Quebec, for example, you would have to assess whether the criminal conviction is related to the person's duties. And so you might be able to refuse to hire someone as a truck driver or a bus driver if they have a DUI infraction in the past. But if they were involved in a bar fight and there's some sort of assault conviction there, well, that may not be relevant if they're going to be driving a truck. So that's something you would have to look at depending on the province. And some provinces like Alberta, I believe, do not have any kind of protection. It's not a protected ground in that province. I believe that's pretty much it. I think we've answered 90% or close to 90% of the questions here. We're going to end it here today. Thank you to everyone for joining us. I believe on the next slide, you will see information on your screen for CPD credits for Ontario, Quebec, and BC, and links have been added, I believe, to the audience chat. If you don't get a chance to claim your certificate today, they will be sent next week, I'm told. And the next event in our fall series is 2025, the Year in Review Collective Bargaining, and that is taking place on December the 2nd. A link to register has been added to the audience chat, or you can find it on our website at fasken.com. Thanks again for coming, and have a great rest of your day.